G'day, I'm Stephen Page from Page Provan Family Fertility Lawyers, and I'm talking today about surrogacy in Sri Lanka for Australians. Welcome to the Australian Family Fertility Law podcast, and if you're watching this on YouTube, don't forget to subscribe. We love our subscribers. Sri Lanka is one of those overlooked destinations that Australians can do surrogacy in, but it has some restrictions. The first is that you've got to be, in effect, of Sri Lankan origin. And I've had the privilege of acting for a number of couples who are of Sri Lankan origin. They migrated from Sri Lanka and then they've gone back there. The second is, in effect, that you have to be a heterosexual married couple. So if you fit those two requirements, then surrogacy is available in Sri Lanka. One of the benefits as someone living in Australia going back to a country that has had the economic catastrophe that Sri Lanka has had is that you can have IVF there and legal advice and the various costs very, very cheaply because Sri Lankan currency sadly is worth so little, at least sadly for Sri Lankans, bargain for Australians. There is not a great delay in finding surrogates. It's fairly quick being matched with a surrogate, and it seems to work pretty well. There's a written surrogacy arrangement drafted by a lawyer experienced in this area, and the IVF process seems to work fairly well as also. The recognition of parentage at the other end, there used to be the way it occurred in Sri Lanka was via adoption. Now, adoption for surrogacy for Australians doing it overseas is problematic. And it's problematic for a couple of reasons. The first is there may be difficulties bringing the child into Australia because either because of citizenship, you've got to establish that you are the parent on the day of birth of the child, and if you get an adoption order later, then you're not or may not be the parent on the day of birth of the child. And the other is that if you have paid some money towards the expenses of the surrogate, and these expenses are low because of the economy of Sri Lanka, you may be committing offences under the various state and territory adoption acts. Every state and territory criminalises overseas adoption if you pay for the actions done here, which are essentially paying for the adoption done there. And there's no distinction between a standard adoption, namely you're adopting someone else's child, and an adoption that arises from surrogacy. So you've got to be very careful with this stuff. What's happened since the economic catastrophe in Sri Lanka is a different way of recognition of parentage, which is that you tell the registering authorities in Sri Lanka that you're the parents. And of course, you do this through the hospital. The hospital is aware of the surrogacy arrangement, and clearly if you commit any offence under Sri Lankan law about registration, you can be prosecuted for that with all the consequences that flow from that. But the effect of that putting your names on the birth certificate and therefore being recognised as the parents in Sri Lanka is that you do not have to go through the adoption process. One would think from that would be fairly straightforward in bringing your child home, in that since April Fool's Day last year, and I've done a video on this recently, there were changes to the family law regulations that said if your name is on the birth certificate and it's in the country that we recognise, then you are presumed to be a parent for the purposes of Australian law. And one of those countries is Sri Lanka. So you would think, we put our names on the birth certificate in Sri Lanka, therefore we are recognised under the Family Law Act as parents in Australia. You may think that, But experience in dealing with the Department of Home Affairs is that the Department of Home Affairs will not be satisfied, the delegate will not be satisfied as to parentage, and will request, I should say, a DNA test to be undertaken through an Australian DNA lab. And once that's obtained and proved, then there should be no great difficulty in obtaining Australian citizenship and returning home with your child. One must take care in undertaking any overseas commercial surrogacy journey not to commit any offence dealing with overseas commercial egg donation or overseas commercial surrogacy. Most of our states criminalise that in one form or another. So it's important to get legal advice this stage, at this end, before, from someone who knows like me, before you go and do it overseas. There is nothing worse when I tell clients, oh, by the way, it looks like you've committed this offence, punishable up to 15 years imprisonment, or it looks like you've committed this offence that can attract a fine of $110,000 or 2 years imprisonment. Things that they could have avoided easily if they'd got expert legal advice at the beginning. Prevention is better than cure. Thank you for watching and listening. I'm Stephen Page from Page Provan Family and Fertility Lawyers. This is the Australian Family and Fertility Law Podcast. If you're watching this on YouTube, don't forget to subscribe. Thank you. We love our subscribers.